My name is Ken Kolpan. I practice law in Boston, and most of my practice is devoted to representing people with brain injuries, both in sports, car accidents, falls, things that fall out of the sky, slip and falls, and I've been doing that since 1981. I had the honor of serving as president of the Massachusetts Brain Injury Association for several years, and have devoted my professional life to representing people who have been injured, including personal injury lawsuits and medical malpractice. So I'd like to talk to you about liability in the area of sports concussion. How many of you are athletic trainers? How many of you are coaches? How many of you are athletic directors? Do we have any EMTs, paramedics, medical people? Oh, terrific. EMTs, paramedics? School nurses. School nurses? Okay, wonderful. So I'll cover some of that. By the way, you also have to use your imagination today, because I forgot to bring an adapter to show my PowerPoint slides. So I'm going to rely on your imagination when I tell you these are some really interesting slides that I was going to show you. Why are we here today? If you have not visited the Brain Injury Association of America website, I want to recommend that to you because it explains why you're here. And one of the reasons is that Dr. Brent Maisel wrote a position paper for BIAA called Brain Injury as a Chronic Disease. It's their website, BIAA.org. Download that paper. It treats brain injury as a chronic disease. Now, as a lawyer, when I read that paper, and a personal injury lawyer, if someone gets seriously hurt, I look at their condition as a lifelong condition. You, as people who treat or evaluate, diagnose, or return to play people with brain injuries, have significant exposure, talking about legal exposure, if something goes wrong. And I say something goes wrong, we're talking about young individuals have a full life ahead of them. Some of you may be thinking, for example, about the NFL recent settlement, which has yet to be approved for good reason. People are taking a second look at it, and you hear $750 million, $750 million, which in the abstract is a lot of money. When you break it down per player and what has happened to them as a result of multiple concussions, it's relatively insignificant. Enough of my preaching about that, but bring the point home to you that there is a lot of exposure. Now, you've done something really wonderful by coming here and getting trained about the rules and regulations in Massachusetts. And one of the things that I carry around, not because I am in any field that treats or coaches, is this card from the CDC, which lists return to play guidelines, symptoms they should look for. And I bring it to depositions to question people like you and ask whether you're familiar with the guidelines here. And why do I do that? Let me give a little Law 101. When someone has a brain injury who has played in a football game or soccer game, the mere fact that they have a significant brain injury does not make for a legal case. The mere fact that someone is hurt is not enough certainly for me and other lawyers to take on a case. There's 4 steps to a lawsuit, personal injury.
They have the adapter, do you want to do that?
I'm not going to. Thank you, and I appreciate you getting it. It'll probably take me more to set it up than it's worth it. So there's 4 elements in a lawsuit. One is the duty, one is negligence, one is causation, and one is damages. All 4 of those elements have to be present in order for there to be a successful lawsuit against you. So if you feel your anxiety being raised a little bit, that's natural, normal, when you hear a lawyer speak about liability and exposure. But I also will cover some of the specific laws which help minimize and protect the exposure that you have as athletic trainers, as coaches, as volunteers, as good Samaritans, as nurses. But what is really important, it's become a legal issue because it's estimated there are about 300,000 sports-related concussions every year. Now that's a quote from 1998. I received an email this morning on my phone that a new study came out from Ohio State saying the last 7 years, up through 2012, the number of reported concussions has doubled in those years. They don't know exactly why. I think a common sense interpretation is people are more sensitive to it, it's being diagnosed more, being reported more. And it's up to about, it was back in 1998, about up to 2.25 million on an annual basis. But what I think is most interesting for all of you is the following statistics. And again, these are available at the CDC website. If you haven't already, go to the CDC website and download the concussion kit for physicians. It is a checklist of signs and symptoms. It's an explanation of the possible permanency of brain injury, and it has 30 to 40 particular references. One of the important things that the CDC has said, that a concussion is a brain injury. And sometimes in this field, we speak of sports concussions. As a speaker this morning said, people who speak of it as a brain injury get more attention when it's deemed a sports brain injury, not a sports concussion. And lawyers are big on words, and we refer to it as a brain injury, not a concussion, though both are true. So, it was reported in 2000 that 5.1% football players sustained a concussion. 14% of those in a season had a second concussion. Interesting, 47% of football players reported at least one concussion during their season, which was 9 times as many as reported by trainers. 35% of football players reported multiple concussions during the season, which was 50 times as many reported by trainers. So there's this disconnect. And for you, the disconnect is in 2 major points. The diagnosis, observation, or identification of a concussion. That's one area where you are exposed. The failure to properly identify, observe, and report is a legal exposure for you. The second area of potential exposure is the return to play guidelines. And you'll find them in the rules and regulations. But what's important about that, because of second impact and slow bleeds, is that someone can have a very significant injury after having suffered a second concussion shortly after the first concussion. I was listening to Peter Brock, and I was reminded of what used to be the sideline evaluation of football players. And the question usually asked of them was, do you want to go back in? That used to be the evaluation. And Pete Brock explained how they would play the game of other questions to get themselves in. And it really explains why there's this disconnect between what is being reported by trainers and what actually football players and others are actually exhibiting. Now, why are you here also? Because there's financial risk. In 2004, there was a fullback named Merrill Hoge who played, I believe, for the Bears. And he, in 2004, so his injury goes back several years before that, he won a lawsuit against the Bears and the NFL for $1.5 million. He claimed that the team failed to reevaluate him for symptoms of post-concussion syndrome or warn him of the dangers of returning to play. And having not been warned, he returned to play, suffered another major concussion, and never played again. Now, I mentioned to you that, and you don't want to find yourself in a lawsuit, and we'll talk about following the guidelines and why that's so important. I said there were 4 elements to a lawsuit. The most important element is breach, or what we call negligence. Those of you in the medical field and trainers, how does a jury determine whether you are negligent? It's not just that the young player got seriously hurt. They look at the standard of care in your particular field, and did you deviate? Did you not meet that standard of care? So when you come here, it's a double-edged sword. You're getting educated about the guidelines, rules, and regulations on diagnosing, treating persons with sports brain injuries, and you're also learning when they can return to play. Those guidelines, rules, and regulations are your friend. They are your friend because if you have followed them and this person still ends up with a serious injury, then you've met the standard of care. You're okay. If once you've learned, well, whether you learn these guidelines in your field, if you're going to volunteer, if you're going to coach, you're going to be an athletic director, or be a nurse who treats, you're presumed to have been aware of such guidelines, rules, and regulations. If you fail to meet them, and that's what a lawsuit is about, they'll bring in an expert who will say, you didn't comply with the rule, you didn't hold them out for whatever period of time, suffered another major concussion, and look what has happened to them. So, learning the guidelines is extremely important. Yes?
Quick question. As a school nurse, say a student is diagnosed with a concussion, and as the nurse, we get clearance from the doctor for the student to return to play. And say the student goes back out and gets re-injured. Is that falling on us? Would that fall back on the doctor because they gave the final clearance?
That's a really great question. And when I was preparing some remarks about this area, the rules and regulations in Massachusetts say it's a medical decision, but a multidisciplinary approach. But to answer your what is really a legal question, let me explain. Everyone involved is a potential defendant. In Massachusetts, we have a principle called joint and several liability, where you can be individually liable and you can be part of a group and be liable at the same time. So if we think of a theoretical situation, doctor gives a clearance for a high school player to come back after having had a concussion, but you're aware that he is still having symptoms, and despite being aware of the symptoms and you're aware that these are significant symptoms, you say, well, I got a doctor's okay, returns. Something terrible happens to this player on the field. They would come after you, and you might say, well, wait a minute, the doctor cleared it. But being aware of the guidelines in Massachusetts, they're supposed to be symptom-free before return. The doctor may be wrong. He or she's going to be sued as well. So I don't want you to sit back and think, well, the doctor's cleared this player's student. I have nothing that I have to do. You do. There's still a burden on you to make sure that he or she is symptom-free. Yes?
In this age of specialization, the kids that you take them out of a sport because they've had one, but their parents put them in an outside one that you're aware of, are you liable? Are you, what do you recommend?
Interesting. I recommend that you document your advice that they don't return to any form of play. And what you're talking about is the pressure from parents. I was consulted by a collegiate basketball player who claimed that the local university made her return to play without following the protocol. She ended up with 3 concussions during her basketball season and wanted to bring a claim against the university for that. And yet she was going to transfer on a basketball scholarship to another university and continue to play. And so the parents and she had some comparative responsibility. I think it's important when you make it clear as to what is required in order to return to play. It's not just to play for the school team that is your team. It's incumbent upon you to explain all reduced activity across the board. There's no artificial distinction, medically or legally, between not playing for the school but playing an outside activity. And there's the regulation. If you don't have it, you should be aware of the regulations, and that one has to be symptom-free, and that's the Code of Massachusetts Regulations 105, 201. Now, as far as Massachusetts rules are concerned, there's only certain people who can return the player back to play. That would be a physician, as you know, certified athletic trainer, a nurse, neuropsychologist in coordination with the physician. So since there's a multidisciplinary approach and everyone here has exposure, let me see if there's some consolation I can offer you that gives you, calms down your anxiety. Athletic trainers. How many athletic trainers do we have? Okay. They have a legal obligation, as you probably know, to identify those with concussions and remove them from play. Coaches. How many people are coaches here? Okay. All right. The regulations are really clear about coaches. It's not only identifying people who should not return to play, but coaches are required to discourage and prohibit athletes from engaging in any unreasonably dangerous athletic technique that endangers the health or safety of an athlete, including using a helmet or any other sports equipment as a weapon. So, coach has a legal obligation to make sure, regardless of whatever rules there may be in the game being played, that none of the athletic equipment is used as a weapon. And we think about spearing in football, we think about lacrosse sticks across the helmet or a mask. Nurses. Nurses' legal obligation in Massachusetts is to monitor recuperating students and to collaborate with teachers to make sure the reentry plan is appropriate. Now, finally, athletic directors. They have a similar legal obligation that the coaches do, make sure kids aren't playing and using their helmets and other equipment as a weapon. Now, people often ask, how do you prevent people from suing you? The answer is that you don't. You don't. Because anybody can sue anyone. And what you can protect yourself is from the liability and exposure. Now, there are a couple of things in sports litigation that has been very helpful to you. There was a case involving the city of Newton many years ago, and I believe it was a female lacrosse player. Are you aware that most student athletes, their parents sign a release, right? Well, sometimes, let me compare that to a situation where you may sign a release like to leave your car somewhere in a parking lot or leave your expensive coat at a restaurant. Those releases, you get a little tag and the back of it says, we're not responsible for anything. Those are void. Those are void against public policy. Those warnings are to discourage people from suing. However, in the City of Newton case, the father signed a release allowing his daughter to play. And I'll give you sort of the paraphrase of what it says. I, the father, on behalf of my daughter, she's going to participate in a voluntary activity, which all the sports activities are voluntary, not mandatory, and that was a key part of this lawsuit, and will hold harmless the city, your city, from any and all actions, causes of actions, and claims, which I as the father have, but I'm also signing on behalf of my daughter who's under 18, and that I agree she will have no claim against you if she gets hurt and when she becomes 18 and is adult. That type of release, in the case of Sharon versus the City of Newton, was upheld as a valid release. So, it is important, and I'm sure the lawyers in your city and town, or the education department, make sure that anyone who participates in a voluntary activity signs such a release. Now, does it protect you from being sued? No, but if you get sued, you may have the right to have the lawsuit dismissed because they signed what is a valid release. The court in that particular case said, since this is a non-essential voluntary activity, the court concluded it was not against public policy to enforce this release. They did add, however, if it's a mandatory activity, such a release may not be enforceable. So that's one consolation.
What year was that case?
2002. The City of Newton case was 2002, I believe. Yes, it was decided in 2002.
So in releases for schools, would you recommend putting in the language of voluntary and non-essential?
Yes. Yes. And keep in mind that if you're dealing with a senior and he or she is 18, the release should be signed by the student as a legal adult. At that point, having the parents sign probably would invalidate the release. Now, there was a case against the town of Brookline in 1996 preceding this, saying in the context of a compelled activity or as a condition for receiving educational services, such mandatory releases would probably not be upheld. Now, what if you're at the scene of a game, you're a nurse, but you're not working, you're watching one of your friends or one of your relatives play. A child gets seriously hurt. Do you run onto the field? Do you respond to the question we sometimes hear on an airplane, do we have a doctor or a nurse available? The law school hypothetical is, man is sitting down on a bench, hears someone drowning, screaming, looks down from his newspaper. Should he rush in to try to save the person, puts the newspaper back up, and the person drowns? Unknown to him, there was a witness coming along, saw the person sitting on the bench. If he or she gets sued, did he have an obligation? Do you have an obligation to go onto the field? There's a difference between ethical obligation, legal obligation. We don't have to get into that. But what if you do go onto the field and render care to this person And despite that, they die on the field. Well, are you liable for what happened? Well, we do have Good Samaritan laws. You probably have heard about that. Keep in mind, Good Samaritan laws, there's a phrase which goes as follows: negligent Samaritans are not good Samaritans. So it's not what we call an absolute immunity. It may be a partial immunity. For example, we have a couple of Good Samaritan statutes in Massachusetts. Do we have any EMS people here? Okay, we can skip that then. But we do have nurses, and this is what Massachusetts law says about this. No nurse who in good faith as a volunteer and without fee renders emergency care shall be held liable. Oh, you go, oh, that's great, as a nurse. You're sitting there, wow, this is great. Well, lawyers look at this a little differently. Not that you're not a nurse, but it also says who in good faith. And what does that mean, in good faith? That's an indication that if you do it negligently, you stomp on the person's chest and break their ribs, when that is not what nurses are supposed to do, then it's not done in good faith. And this is a limited protection for you. That's for nurses. How about people who volunteer? I've volunteered to coach teams. Some of you, in addition to the work that you do, volunteer. We have another law which protects volunteers. You must have no compensation, but if you do that for free, as a manager, coach, umpire, referee, or as an assistant to the coach or manager, you're not held liable. But keep in mind, as lawyers start thinking about this, you've got to truly be a volunteer, no compensation, then this statute would protect you. Most recently, in 2014, they expanded this protection to any person who in good faith renders emergency treatment shall not be held liable. But of course, as in every law and protection, there are exceptions. And it says, except when there's gross negligence or willful and wanton conduct. Now, it's not important that you get down these phrases and all that. What I'm trying to bring home to you is this, that if you follow the guidelines, if you do what you're supposed to do, there are laws out there that prevent you being held liable if you've complied with the rules and with the statute. How many of you work for a town, a city, or the state? A good portion of you. Okay. Now, it's kind of interesting. There's a law in Massachusetts called the Tort Claims Act. And that act is for governmental entities, municipalities. What it says is individuals who are employed by cities and towns cannot be sued. The town is sued. And there's a limit of $100,000 as the most one individual can recover against a town. Now, I won't ask for hands, but some people work for towns, but they're not employed by them. They have a contract with the town. Those people who are under contract and not employees, they do not have the benefit of the Tort Claims Act. They are not protected. They can be sued individually. That's known as 258, and that's an important law protecting most cities and towns. Now, this case of Sharon versus the city of Newton was a lawsuit under that law where the most that could be recovered is $100,000. Now, if you've heard of other cases, there were a couple in the state of Washington. One was an 8-figure settlement on behalf of a high school football player. Their laws are a little bit different. A city here, if there were a judgment against them for $8 million, the judge would reduce it to $100,000. $100,000 if it's brought under 258. And by the way, that law, because they would name the city of whatever, you would be an important witness. The city has an obligation to insure you financially and provide representation.
Even if negligence existed?
Even if negligence existed, what's the rest of the question?
Still the max is 1,000.
100,000.
I'm sorry, 100,000.
That's correct, and it's one of the discouraging things from my side of the table of taking cases involving seriously injured athletes on school grounds and school activity. And that's a legislative policy that was made and voted on, and there's been a lot of lobbying to have that increased, but unsuccessfully. 4 minutes, terrific. Okay. All right. All right. One of the things was said, and I'll respectfully disagree with one of the physicians. I don't practice medicine. A couple of phrases come to mind. One of the NFL experts that I have in one of my cases has said to me, and said on the record, time is brain. Time is brain. And where I disagree, and she may medically be correct, as to whether or not such concussions are emergencies or not. I think about the Natasha Richardson case, and for those of you are familiar with it, it's a young actress who fell at a ski resort and unfortunately died of, I believe, a bleed. And I'm not suggesting that anyone did anything wrong. But given what sports brain injuries are, that 10 to 15% of traumatic brain injuries, according to CDC, can lead to permanent brain damage over one's lifetime, 10 to 15%. Even so-called minor traumatic brain injuries. These have to be taken very seriously because a concussion is a brain injury, One of the other things to keep in mind when you are evaluating people in sports, it's not only acceleration, deceleration that can cause the brain injury to these athletes. I don't know if you remember back to your nursing days, but if you ever saw the underlying part of the skull where the brain sits, and we use this type of demonstrative evidence in court all the time. We take this anatomical model, take the top off, have the doctor squeeze the brain, and it's very realistic, I've been told, and then take the brain out, and we show and pass around to jurors the bottom of the skull. The bottom of the skull has these very sharp ridges. So when there's any jostling that goes on, a lot of the damage can be in the front where these ridges are, and brain tissue can be torn. It's very, very serious. So just sort of to refresh, yes, you have exposure. Yes, you can be sued. By studying and complying with the guidelines, it's probably your best protection against any type of lawsuit. The observation, diagnosis of a sports brain injury is key, and when and if the person returns back to their sport. When does it happen? What is the proper evaluation? And when are they symptom-free? Those are the two tipping points for each of you. In a few minutes are left. If there's any more questions, I'd be glad to answer them. Yes?
What's the legal duty for, say, like the nurses? If somebody has a concussion, they go to the doctor, they get cleared by the doctor, do they have a legal obligation to do a whole system, the symptoms evaluation before they play, or when that medical note comes back to them?
That's a great question. Knowing that Massachusetts law requires that the student be symptom-free, and that when the doctor clears, that's a snapshot in time, and you see him, it's another snapshot in time. Probably the better practice is some type of checklist to ensure that when the doctor signed, that still the student athlete is non-symptomatic. And I threw out a hypothetical. If you become aware that they are symptomatic, you just can't rely upon the doctor's clearance. You have some exposure. Yes?
The problem that we find is the doctors, they'll write we have them fill out the Massachusetts form and they'll clear them, but then they say like if symptom-free for 2 weeks or times, 1
Sure.
And
Sure.
in our district, we don't have an athletic trainer. So the 2 high school nurses, Amy and myself,
Yeah.
we have to communicate that to the coach and to the athletic director. And, we're in communication with the student and the family, but outside of that, we're not out in the field.
No, you're not out in the field. And I think what the doctor is doing is what we commonly refer to as a CYA. Right. And that's good.
We have a trainer.
That's good. What the doctor is saying is, the snapshot in time when I saw this student athlete, she is asymptomatic. All right? But I'm going to warn you, the rest of you, in this multidisciplinary approach, the rest of you should check. And he or she, the doctor, is saying, don't just rely on this clearance. You have a legal obligation to do more. I'll leave you with this quote. The quote is, and you'll have to imagine my 21-year-old in his football uniform and basketball uniform. And I kid, is a picture of him when he's 10 years old in a football uniform. Very proud of him. He's the only defensive back who never had a tackle all season. And somehow he was always the last one to the runner. And I was very proud of him that he did that. But the quote I'll leave you with is, no head injury is too severe to despair of, nor too trivial to ignore. Anyone know where that came from? Came from the 4th century BC, Hippocrates. So thank you very much for your attention. I'll be around if there's any other questions.
Thank you.